what I'm trying to do here is there is a book that I've used for a textbook in here before, and I decided not to use it as I decided not to require you all to buy it. But it's a really good handbook, and I'll put all this online so you don't have to worry about photographing or necessarily or writing it all down. You'll see better versions of these notes online soon. But anyway, the book that I'm kind of following here is called William Canby's American Indian Law in a Nutshell, and it's a small book, but it is just dense packed with information. It's basically a reference book. You can read it kind of like a textbook, but it is. But it's good, it's a really good handbook if you are looking for specific stuff. So, and it really gives you the things that are most important. So, out of that little handbook, I'm giving you the sort of the intro that Canby provides to, beginning to understand American Indian law. Okay, that's pretty much what we're doing here. So Canby says that there are several procedures to establish federal Indian policy. And by policy, what we mean is not necessarily law, and not necessarily, basically all federal Indian policy is going to be shaped by one of these what we might call procedures. Okay. Probably the best way to look at it. And sorry about the flickering thing. I do have an experiment I'm going to try with this after class to see if I can overcome the flicker problem, which is a VGA cable problem. But anyway, there are several procedures. And Indian policy began with treaties. And I told you last time that the treaties, the very first treaty, was with the Delaware, between the United States and the Delaware in 1778. But of course, the United States was just a rebel set of provinces in 1778. We had not won our independence, and we weren't recognized internationally as a sovereign state yet. And because of that, we did not have a lot of authority to wield as a sovereign power, okay? Nevertheless, 1778 is usually identified as the first Indian treaty, and that's with the Lenape or the Delaware, and in essentially Pennsylvania. The treaty process would go on throughout the end of the 18th century, after independence, after 1783, formal identification of the United States as a sovereign independent state, all the way until 1871. And in 1871, the United States Congress decided that there would be no more treaties made with Indian tribes. Okay, so this means that any treaty between the United States and an Indian tribe has to be ratified by the Senate and signed by the President, and it is considered international law. It is considered law of the land, equivalent to the Constitution, okay? At least that's what treaties are initially considered. They are considered the law of the land. They cannot be changed, except in the case of Indian treaties, they can be abrogated. In the case of the United States, there is one way that Indian treaties can be abrogated, and that is if the United States Congress says they will be abrogated, they will be ended. So the United States Congress calls the shots between the relationship between the United States and Indian tribes. It's the United States Congress that is the key. And by Congress, I mean both the House and the Senate. Okay? Initially, the Senate was more important, but in 1871, this change actually reflected a sort of a power struggle of the House over the Senate with regard to international treaty making. But nevertheless, it doesn't really matter. Another procedure that federal Indian policy is established is through federal statute law. That is, the laws that Congress passes, that the president signs. An example would be something like the Indian Removal Act of 1830. We'll talk about all these different statutes and treaties, not all of them, but the more important ones that have gone to shape and change, particularly Indian policy. So federal statute law is basically congressional acts, bills that are then signed by the president and become laws. And of course, those laws can be found to be unconstitutional, right? Later, they can be repealed, and but that's the second more obvious type of Indian policy. Now, there are a lot of other ways to establish Indian policy, and one of the ways that is, to me, the most dangerous, the one that has the least degree of democratic process, is the administrative rule. This is essentially a rule that's put in place by a bureaucracy. The bureaucracy, in this case, is typically the Bureau of Indian Affairs, or in the 19th century, the Office of Indian Affairs, and essentially the India Office, okay? This is an agency within the larger branch. Today, the Bureau of Indian Affairs is an agency within the Department of the Interior, okay? And historically, originally it was in the Department of War, which was essentially the Department of State and Defense. So the BIA is not the only federal agency that has something to do with U.S. Indian policy, but most of it, okay? We'll see a few other examples, but most of the time it's the Bureau of Indian Affairs that's making rules. And essentially what I say is that, the administrative process, or the agency, Bureau of Indian Affairs, or if it's perhaps the Office of Indian Education or the Indian Health Service, those are some other ones that are not necessarily not in the same department. But those agencies are run by professional administrators, bureaucrats. They are supposed to be nonpartisan in their operations and what they're doing. They're nonpartisans. Even though the head of the agency and the head of the department will typically be political appointees and will be political actors, political players, but most, the vast majority of workers in the federal agencies are lifetime professionals that aren't going to lose their job when a new president is elected or a new administration, new party comes into power. So the professional administrators are the ones who develop these rules for the most part. Now, the directors of the agencies, of course, are appointed by the president, and then they are vetted by Congress. You all know that, right? It goes just like any other federal agency. These people are doing their jobs, and they're supposed to be doing things nonpartisan. Anyway, those administrative rules, the BIA and other federal agencies can create rules that are essentially analogous to statute law or to treaties, but of course they are subject to change whenever a new administration comes in. So, but it really doesn't change that much of, it might slow policy making down, it might, a little bit, but for the most part, it's not a huge, massive shift in policy making, because most of the stuff that goes on is more mundane and long term. Nevertheless, these are, the rules that are established here can be very, very significant for short amounts of time. Short amounts of time meaning between changes in administration. Okay. All right, another process or another procedure for establishing Indian policy is federal case law, specifically, not just Supreme Court, but any federal case law. So you have the federal case laws. We will talk a lot about these Supreme Court cases and how these establish precedent for Indian policy. One thing that we'll see in a second, is that Indian policy in the United States for the last 200 and some years has gone through these different stages, and sometimes one direction of Indian policy is going along and you think, well, times have finally really changed, and then whammo, they'll turn around and go back the other direction. Something will happen. And it's not necessarily just the election of a president. It could be power in Congress that changes. It may be a president who has more of a proactive policy and proactive ideas. Okay, so federal case law is really, really important because that sets legal precedents and kind of has inertia. So once you have these, and we're going to talk today about some of the most significant Supreme Court cases that have pretty much defined Indian country and defined the parameters of sovereignty for Indian tribes. Executive orders. And executive orders for Indian policy went on until 1919, and after 1919 you have, of course you know what an executive order is. That's basically executive power while the president is in office can put something into motion and say, okay, this is just an order, we're going to do this, we're not going to vote on it, and if a new regime gets elected later, what's the first thing they do? They rescind that policy. Okay, and we saw that, of course, with Trump rescinding all of Obama's stuff, and getting rid of all of these, getting rid of a lot of the executive order stuff that Obama had put into place without voting. So the executive orders were actually pretty important, and there were a lot of Indian reservations that are established with executive orders. So we'll see some examples of that. And then after 1871, after the treaty process ended, we have something new that's referred to as formal agreements. And these are basically still treaties. They're just not called treaties, but they are kind of negotiated agreements and not really contracts, but established law that are made between Congress and the Indian tribe. And finally, between Indian tribes and the states, all of this other stuff is all federal policy. Between Indian tribes and states, we have something that's fairly new, and it's called the compact and the contract process and the MOU. What's an MOU? Right? Memorandum of Understanding. So essentially like a contract, and it's a contract to do certain things, to have certain responsibilities. Okay? So this is actually where a lot of the stuff is really interesting these days and very exciting. A compact is an agreement, formal agreement between a tribal government and a state government, in which they outline their various responsibilities that they've agreed upon. And this happens because federally recognized Indian tribes and the 50 states of the United States are very close in terms of their position within the United States federal system. You can't say that states are superior over Indian tribes, and of course you can't really say Indian tribes have superior status over the states, but they're close. And their purview, their prerogatives often conflict. So much of the federal case law, it involves issues that arise between state governments and tribes. Okay, so we'll talk a lot about that. So you'll see, Arizona getting sued, or California, and so that is it's really, really common. We'll see these. So rather than fighting in court, tribes have realized and states have realized that it makes a lot more sense to negotiate and work things out ahead of time rather than go to court, because going to court just slows everybody down and costs lots of money. So the compact process is one of those things that are new. Any questions over the procedures of establishing Indian policy? And just keep all these things in mind. Whenever we look at something like Johnson versus McIntosh, okay, what would that be? Be able to kind of identify what type of procedure is establishing this policy. Johnson versus McIntosh, what would that be on this list? It's a Supreme Court decision, all right? So that Supreme Court decision is emanating from a dispute between the state and Indian tribe. And like the Indian Removal Act is one of many different statutes that put into place federal Indian policy. A lot of these recently. Okay. So anyway, move on. Now, going back to William Canby, he identifies what he calls 4 themes of sort of the doctrinal basis of Indian law. And these are really pretty interesting. So Canby's 4 themes, number 1, and these are kind of observations, right, that he's made. Number 1, tribes are sovereign. They're sovereign entities. And by entities, we just mean they are recognized as legitimate governments, governmental bodies, or political bodies, recognized as sovereign, legitimate political bodies by the United States Congress. Sometimes they lose that status, and Congress will no longer recognize them as such. Okay? So tribes are sovereign entities with inherent powers of self-government. That's basically what sovereignty means for Indian tribes in the United States. They are inherently sovereign, and therefore they have a tradition of identifying as a group, and they have the right to identify as a group and the right to govern themselves. That's what the United States government considers Indian sovereignty. But keep in mind that Indian tribes are a group and not individual persons. I've said that before. There's a reason I keep saying that. Okay? The United States government deals with Indian tribes as governments, not as individuals. The United States government does not deal with individual native peoples on a government to individual basis. It only deals with governments to governments, government to government relationships. Number 2, the sovereignty of tribes is subject to exceptionally great powers of Congress to regulate and modify the status of the tribes. That is what we refer to as the plenary authority or the plenary power of Congress. Plenary just refers to absolute supreme authority over the relationship between Congress and the tribe. Now why? Why is Congress the supreme authority when it comes to the relationship between the United States and Indian tribes? This is just, there's no reason you should know this. And you might have a response to that, I don't know. What I do for a really, really long HDMI cord. Plug directly into that thing. I'm gonna try to use Chromecast and see if that works. We'll see. All right. Before Congress, what I'm going to say is Congress is the inheritor. Congress is the heir of what? What power? Well, the United States, of course, is the heir to the British Empire, at least for what we own in North America, most of it. So the United States inherited its relationship with the Indian tribes from its colonial mother country, from Great Britain. Now, in Great Britain, however, the sovereign means something else. There is a sovereign. Who is the sovereign?
The king.
The king or the queen, the monarch. So in a constitutional monarchy, all right, the monarch holds the sovereignty. The monarch determines the relationship between the country, his country, her country, and the foreign countries. In the United States Congress inherited that power from the British Crown. Why is that? All you have to do is look at the opening of the Constitution. What's the first line of the Constitution? What?
All men are created equal, or that's the other?
I believe that's the Declaration of Independence. We, the people of the United States, okay? So Congress is the people of the United States. The people are the sovereigns in the United States federal system. That's our concept of sovereignty. In the United States, we don't have a king, we have the people. The people are the sovereign. The people are represented in Congress. So Congress is the representatives of the people. Congress represents the sovereign people of the United States. Okay? So, it's a little different. You know, the sovereign, the monarch of England, of Great Britain, could change policy and determine whatever policy it wanted with the Indian tribes. And that's significant before 1776. But after 1776, it's the United States that has essentially inherited that sovereign power, and Congress then has the plenary power. So anyway, I'm sorry to go on for on and on and on and on like that, but the plenary authority of Congress is everything. Even though the Bureau of Indian Affairs is an executive branch department, you know, and the president seems to have a lot of power there, and the president can do executive orders, it's really Congress that matters. The power to deal, number 3, the power to deal with and regulate the tribes is wholly federal, and states are excluded unless Congress delegates power to them. That's sort of observation number 3, really significant theme number 3. We'll continue to see this over and over. The power to deal with and regulate the tribes is federal, not state, and the states can only have a say in it if Congress specifically delegates such power to states, which it has done. And here we're talking exclusively about the federally recognized Indian tribes. Okay? When it comes to some tribes are state recognized Indian tribes only. In that sense, the relationship between the state government and the non-federally recognized but state recognized tribe is between the state and the tribe. Interesting, huh? There aren't very many of those. Most of them are in like Virginia and New York or Massachusetts. Oh, by the way, I wanted to say this one thing. For the map quiz for the first exam, or for the things to know about on the map, the things to know on the map. We're going to start off with Oklahoma. Hopefully that's more familiar to you. We're going to start off with the state of Oklahoma, and I'm going to ask you to be able to identify the Oklahoma Tribal Statistical Areas, OTSAs, okay? Oklahoma Tribal Statistical Areas, which are essentially the reservation boundaries of the state, and I'll give you a master map of those, so you'll know what they are and where to, how to study them, and then you'll see some quizzes about them as soon as I can get the quizzes made. But we're going to start off with just Oklahoma, okay? Which is actually quite a bit. So, especially, and then there's the northeast corner in Ottawa County has a bunch of little tiny OTSAs. So that's kind of a caveat of that. Number 4, theme. The federal government has a responsibility for the protection of the tribes and the tribes' properties, including protection from encroachments by the states and their citizens. That is really important. That's the part of the trust relationship of the United States toward the Indian tribes. It has an absolute responsibility to make sure that the tribes and their property are protected from encroachment, that is, the violations of their sovereignty by the individual state governments, by the municipal governments of states, and particularly by individual citizens of the states. So, these are 4 important themes that we'll keep running into. I just want to make you aware of that. Any questions over those? Observations? All right. Now, let's talk about the whole idea of Indian sovereignty. What does it mean? Where does it come from? Sovereignty is one of those words that is all over the place. It's a buzzword too. So you have, the professional activists that like to throw that one out a lot. Unfortunately, a lot of people use the term sovereignty without much knowledge as to exactly what it is. Sovereignty. In the case of there's sovereignty, and then there's Indian sovereignty within the United States federal system, which is what we're talking about. Now, according to Marshall, who would Marshall be?
John Marshall.
John Marshall, Chief Justice of the Supreme Court. John Marshall, long-serving Chief Justice back in the early part of the 19th century. A lot of schools named after John Marshall in Oklahoma and elsewhere. Anyway, according to Chief Justice John Marshall, in the federal case, the Supreme Court case Johnson versus McIntosh in 1823, unfortunately one of your readings says 1824, but it's 1823. Tribal sovereignty exists, but American Indian nations don't exist as independent nations. So tribal sovereignty exists, but because they are not independent nations within the United States, their sovereignty is tenuous sovereignty, subject to the plenary power of Congress. Right? So tribes are sovereign as long as Congress says they're sovereign. And Congress can decide that it's not going to recognize Indian tribes anymore if it wants. Tribal sovereignty is dynamic and can change rapidly with changes in the politics of the United States, as we'll see. Sometimes it's a 180-degree turnaround, as the case in 1933-34, when Franklin Delano Roosevelt won presidency in 1932. He implemented the New Deal and completely changed Indian policy. And then it would pretty much completely change again in the early 50s. So, and then it would change again around 1970. So in the 20th century in particular, it's changed rapidly, dramatically. Thirdly, tribes are analogous to U.S. state governments, but they were not created by Congress as the states, most of the states were. So they are problematic, and their internal affairs are their own business. Their internal affairs are their business. So that means that states cannot interfere with the workings of Indian tribes. The federal government can, but generally chooses to allow them autonomy. So in some ways, tribes are like states, but you also have to remember tribes are not spatial entities like states are. Okay? Tribes exist as similar to state governments, but not as territorial entities at all. Tribes are groups of people. And that, to me, is what makes the whole, existence of Indian sovereignty so interesting. The United States is, for the most part, the Constitution, when it comes to sovereignty, is very, very territorial. Our elections are, we have a two-party system, right? We have a two-party system. We have a bicameral legislature, a national bicameral legislature, one of which is specifically territorial and has to be reapportioned every 10 years, So the House of Representatives has to be worked out. It's very, very spatial. So to a geographer, if you're interested in geography, the political geography of the United States is just part of the United States system. It's very territorial. But, and of course, the two sovereigns that we always recognize in the United States, the federal government, okay? The federal government shares sovereignty with the state governments, and the states are definitely territorial, right? So the state's authority ends at the state's border. Federal government has some overarching authority where states don't necessarily have it, as in currency and international trade and trade between states. Those are really important federal prerogatives. Indian tribes, because they're not territorial, they may have territory, they may claim territory, but not all of them do. They may, because they're not territorial entities, they can grow, they can change, they're dynamic. All right. Okay, so let's move on here. Canby often refers to something called a pendulum of federal Indian policy. Pendulum, like in a grandfather clock, swings back and forth. So policy tends to swing back and forth, but it's not necessarily because of a change in the presidential, who's in the White House. It's actually a lot more complicated than that. So this metaphor of a pendulum refers to the back and forth or left and right, left-right tendency of federal policy to change drastically for Indian policy. However, it tends not to be, because of our specific federal system, because of the bicameral legislature where you have senators elected for 6 years and then you have House members elected for 2 years and they're all offset. And because of a number of other things, there's lots of redundancy, there's lots of stability. One of the beautiful things about the United States federal system is that it is slow to change. Okay, whether you hate gridlock or not, gridlock was intentional in this system. Rapid change was something that the founders tried their best to avoid, and they created a system that can't change very quickly. So, despite that metaphor of a pendulum, the changes that take place have to, they really aren't that extreme. There may be people in Congress who are very much anti-Indian sovereignty or pro-Indian sovereignty. They tend to coexist. And while you might have a Congress leaning one way, you might have, for example, you might have a president that's far right, and you might have a Congress that's far left. So when it comes to Indian policy, for the most part, you don't get a lot of change. It's only when you get sort of one-sidedness that you tend to get these extreme changes. So anyway, the other thing we need to consider is the judiciary. The judiciary, particularly the Supreme Court, and then the executive branch's authority to appoint federal judges. That has a heck of a lot to do with where Indian policy goes. So, and of course, the Supreme Court makeup can be pretty significant in terms of directing that policy. As we'll see, though, sometimes you have a powerful president that defies even the Supreme Court of the United States. What president would that be? One of the earlier presidents. Shaping Indian policy would be Andrew Jackson. We'll talk about exactly the example here. So, Johnson versus McIntosh. This is one of the most important Supreme Court cases with reference to definitions of Indian sovereignty and Indian country. A decision made in 1823 under Chief Justice John Marshall. Basically, it found that indigenous people within the boundaries of the United States retain a right of occupancy until Aboriginal title is extinguished. And that can only be done when the federal government takes land through purchase or conquest from an Indian tribe. Now, you're going to read a little bit on Johnson versus McIntosh, but what it came down to was, it doesn't sound anything like Indian tribes, right? But it actually involved the sale of land from an individual Indian, McIntosh, individual Indian sale of land to a non-Indian. So the question was, can an Indian sell his land if it is considered tribal land? And this early decision said, no, can't do that. Members of Indian tribes can't go sell their tribe's land. Okay? They can't do that, says the United States. Yeah.
What about in the oil and gas industry? If somebody's wanting to drill on their land, can they do that or no?
Yeah, certainly. And if you're talking about mineral rights, this has led to the largest class action lawsuit against the federal government in the United States history in the late 1990s. The Callahan, anyway, we'll talk about it later. Yeah, I mean, what the difference is, that's a really good question, Hunter, and you stumped me here. But it's a really good question because it's so, I can't really answer it because the answer would be so complex it would just confuse everything right now. We have to get into what's referred to, and we don't have time for this today. We're going to talk about something called the federal trust, the United States federal trust relationship with the Indian tribes. And to do that, we have to understand what a trust is first. But to answer your question, no, you can't sell Indian country to anyone except the United States federal government. Okay, maybe that answers your question. I hope. But we'll talk a lot about this. Okay, so now this requires us to know some terms. Okay, so here's some really underscore some of these terms. Occupancy, aboriginal title. We'll talk about that in a little bit. Aboriginal title, really important term. I think I mentioned it last time, didn't We talked about that? So in the United States, it's actually referred to as original Indian title. Its aboriginal title is what is recognized by the, by the British tradition of sovereignty. It recognizes the right to claim and to use land that they have always had since time immemorial. In other words, since before anybody has a record. So, a right of occupancy, really important, underline that. Aboriginal title is a right of occupancy only, okay? Now, the right of occupancy, the Aboriginal title, can be extinguished only by the United States federal government, not by states, not by individuals. And the reason for that is because it's the United States that deals with the Indian tribe, not the individual. So the United States can purchase land from Indian tribes, but the United States citizen cannot purchase land from an Indian individual or an Indian tribe and have its Aboriginal title extinguished. Only the federal government can extinguish Aboriginal title, the right of occupancy, because it's a nation, not an individual. This is always a sticky point. Anybody not following me? Okay. So keep in mind, only the United States only deals with tribes, only deals with nations. It does not deal with individuals. Now, the United States federal government can take land by purchase or conquest and declare it free from Indian title, free from Aboriginal title. It can't do that. Why? Because Congress says it can. Right? Now, fortunately, the United States has a tradition of not conquering, at least in most cases. All right. Now, even when it does engage in what we might call conquest, in other words, there is a British legal tradition that safeguards the loser. Okay, and that is a term referred to as a taking. Okay, and you know that in something like eminent domain, when say that you want to build an interstate through your backyard. Basically, the government says it's to everyone's benefit that you hand over the land, but then there's something in the Constitution that says the government can't just come take your property and say sorry. What has to happen?
They have to compensate you.
Exactly, right. The Constitution requires that anybody who loses property to the government is compensated at, it doesn't say in the Constitution fair market value, but they have to have just compensation. And of course, this was a big problem back in the colonial days because the British Crown would house soldiers at people's homes and take crops, and take livestock and that sort of thing if it needed it, and would not compensate anybody. They didn't have any recourse. So this was certainly within our Constitution. The federal government can't just take. If it has to take, it has to have just cause, it has to have a good reason, and it has to compensate you in a fair way. So even in the case of indigenous peoples losing land, the United States has a tradition of making an effort, even though it doesn't have to through the Constitution, because the Indians are not included in the Constitution. Because Indian tribes, because it's the right thing to do, the federal government has established different policies, mostly in the 20th century, to make good on those takings. An example from 1980, you'll read about it, but George Armstrong Custer was, known for a lot of things. One of the things that you probably didn't know about him was that he rode into the Black Hills in the early 1870s and was somewhat responsible for publicizing the gold strike in the Black Hills of South Dakota, western South Dakota. Well, the Great Sioux Nation claimed the Black Hills, but what happened was a gold rush ensued into Indian country, and over time, the Lakota lost the land unfairly. They still have a claim to that land. They have a legal right to the Black Hills in the United States. I mean, they have a legal right to the land. In 1980, the United States offered a settlement to the Lakota of $200 million for just saying, we owe that to you. We owe it to you, okay? So that we can clear the title. We can clear the Aboriginal title or the original Indian title from the Black Hills. 1980, $200 million. Lakota said, no thanks. They said, we want the land back and we still have legal claim to it. Okay? So this is not Russia. This is the United States. The United States said, okay, sorry, we still owe you. But we haven't settled on a price yet. Okay? So the Lakota didn't disappear. They didn't suddenly start dying. They still have this claim. So anyway, the United States will seek to compensate, the tribe as it can. Now, there are other fantastic examples of tribes losing land for pittance. In other words, they ceded land in a treaty, and the compensation for losing that land was not even market value for the land. And in the 1940s, the United States established something similar to the Waitangi Tribunal. Remember we talked a little bit about that? To kind of settle those old claims. It's called the Indian Claims Commission. And it ran throughout the middle part of the 20th century. And any tribe that had a legitimate legal claim could come and, voice that problem to this commission, this Indian Claims Commission. And the Indian Claims Commission would then determine, would basically say whether or not, this tribe has a case, and they would try to work out what was owed to the tribe with the idea that once that settlement was made, it was basically settling out of court. Once that settlement was made, then there would be no more claim. There would be no legal basis for any claim by that tribe. So you might say, well, that was fair. But then you might say, well, not really, because this just gets the United States off the hook, And if the tribe agreed to that settlement, then they can never bring a suit against the United States again. It's clear. They're squared at the bank. All right. Then we get into this this idea of the inheritance of sovereignty. So why is it that the United States is the only one that can extinguish Indian title? Well, because the United States government's not going to put up with Spain coming in and saying, we want to buy some land from you, okay? That would be a contradiction of the state system of international law. So, for example, the United States, say the United States wants to purchase, where do we want to purchase? Maybe we want to purchase Bolivia, okay? So we've got enough, well, in Bolivia, I think, or maybe it's Peru, is where the lithium mines are popping up now. lithium ion batteries are such a big market. Well, lithium can only be mined in a few places, but I think it's Peru or Bolivia. And say the United States just says, well, let's just buy Bolivia. We've got the cash. We'll put it on our credit card, and like everything else. And we'll purchase Bolivia. Well, Bolivia's not going to do that, right? We're going to say no. We don't give up our sovereignty to you. We don't do that. If you want Bolivia, you're going to have to come take Bolivia. Right? So it doesn't work within the state system. Now, this idea of the doctrine of discovery goes back to the 14th, 15th centuries, in which European powers respected each other's claims unless they were at war. Okay, so that was we'll come back to this idea of doctrine of discovery, but essentially it's the inheritance of international authority, internationally recognized authority over territory. The United States is going to only recognize its authority over over territory within the boundaries of the United States. It's also one of those parts of Johnson versus McIntosh, that it's sort of like a little bit of dissonance on the case of the United States, saying, well, you're not an independent sovereign, so you're a dependent nation. Okay, so anyway, there are three really important cases that really shape the development of Indian sovereignty and therefore definitions of Indian country, okay, or at least they begin to shape definitions of Indian country. The second one, we've talked about Johnson versus McIntosh in 1823. The second one comes around in 1831, and it's Cherokee Nation versus Georgia. You probably have heard of it. It's a Supreme Court decision, or an action, it's not a decision. A Supreme Court action based on Article 3, Section 2 of the United States Constitution. Well, what's that? Anybody have a Constitution handy? You can get a free Constitution on your phone. I'd recommend that. And we'll maybe come back to it. But what happened was the Cherokee Nation was experiencing a problem with the state of Georgia. Okay? Essentially the case was never heard. It was thrown out because what the Cherokee Nation did was it basically solicited the United States Supreme Court and said, we're a sovereign nation of people, and the state of Georgia is not recognizing our sovereignty. Okay? This has to do with what was taking place in the Cherokee Nation in northwest Georgia in around 1830. Okay, 1831 is, of course, is a year after the Indian Removal Act is passed. All right. And there was a lot of pressure on the Cherokee Nation and a lot of the other 5 tribes to cede territory and move west of the Mississippi. It's a complicated historical story, but for the most part, what happened was the state of Georgia declared all of the laws of the Cherokee Nation to be null and void. The Cherokee Nation had written its own constitution in 1824, I think it is, or maybe it was 1828. They wrote their own constitution, they had their own judiciary, they established their own legislature, bicameral legislature, right? So the Cherokee Nation had set up shop. They had set up their own government within the boundaries of what Georgia defined as its own territory. So if you go to the Constitution, today's Tuesday.
Trying to go testing.
Yeah, I hope it's a test. Okay. All right. I didn't think it was supposed to rain today. Can't really tell in here. So anyway, the United States Supreme Court hears this this complaint by the Cherokee Nation against one of its states, the state of Georgia. And because the state of Georgia declared all of the laws within the boundaries of the existing Cherokee Nation to be null and void, it was saying that Georgia was refusing to recognize its sovereignty. So basically the Cherokee Nation went to the Supreme Court as an independent state would, say as if, you know, Switzerland would come to the United States and say, we've got a beef with one of your states. And so at that point is when John Marshall and the Supreme Court said, okay, yeah, you're a nation of people, but you're not an independent nation outside of the United States. You're a dependent nation. And you're not a foreign nation, you're a domestic nation, okay? So, splitting hairs, right? John Marshall declared Indian tribes to be domestic dependent nations, not foreign nations, and therefore ruled that the Cherokee Nation was a state and ruled that the Cherokee Nation was had its presence as a state and was ruled by a nation which is a distinct political society separated from others, capable of managing its own affairs. In other words, it was sort of a double-edged sword. This pretty much set into play the parameters of Indian sovereignty. If you're an Indian tribe, you have the right to self-government, but you are not a foreign nation and you are not independent. You're subject to the plenary power of the United States Congress. Okay? So it established, however, what we might call the sort of the trust relationship of Indian tribes with the United States federal government. And this is that you can read through the entire decision. I think it works. I think it's okay.
Right.
Okay. All right. So they heard me. So it's established a federal obligation to the Indian tribes as wards of the state and in a state of pupillage. Get it? All right, we're prepared. That's good. What does that mean? If you are, this may have happened to some of you, hopefully not, but maybe happened to somebody you know. Say they're a minor, say they're like 15 or 16 years old, and their parents are both killed in car wrecks. Okay? And their parents have a lot of money. And more than likely, if they did have a lot of money, they had set up a trust, an irrevocable trust, or a revocable trust. But if it's an irrevocable trust, it's irrevocable after they die. So, an irrevocable trust is something that is going to be designating assets that the parents would basically be willing to the child. But if they're not of age, if they're under 18, and more than likely if it's been set up in a trust, then they're not going to have access to those assets until they're of mature age. Oftentimes people will say 30 years old or 25 years old or something like that. Okay. So what happens in the interim between, say, the death of the parents at the child's 15 years old and let's say that the age at which the child is considered mature enough in the trust at age 25. What happens in those 10 years to the assets? Well, they're cared for by a trustee. So a trust is basically saying, okay, here are the assets that are going to go to this person, but we can't trust them with them yet. So we're going to designate a trustee to hold these assets until they're old enough to take them. That's a trust. So the trustee actually has the ownership during that interim period, but with the trust that he or she is taking care of those assets for that person. So banks do this, they act as trustees, but it's usually, often like a family member or something. So, say for example, I hate to make these examples terrible, but you have a brother and his wife who were killed in this car wreck. They have a lot of money. They've left a trust to a 15-year-old kid. You've been designated as a trustee. Okay, well, you have authority over those assets, over that money, that capital, real estate, whatever it is. But you have a responsibility. You've been given that responsibility by your loving family member to watch over it and to protect it until that child is of age to use it or to take responsibility and take ownership of it. Okay, so that's very, very important. Being a trustee is a serious position of trust. Okay, because what can you do with it? You could be an unscrupulous character and maybe live high on the hog with it in that interim period without many legal ramifications. Okay, it's kind of like having power of attorney over somebody. So anyway, you have the trust relationship. Then in the trust relationship for domestic dependent nations. Okay, this is weird. Indian tribes are governments that have a right to govern themselves, but they're not quite ready for independence. They're in a state of pupillage, according to John Marshall. And therefore the tribes, Indian tribes, not individuals, but Indian tribes are wards of the federal government, wards of the state. What that means is the wards of the United States federal government. So the United States federal government has inherited these children, okay, these tribes, and the United States federal government is then the great father to the tribes. In fact, they used that language in Indian treaties in the 19th century. It was very often the case that the negotiators from the War Department would go meet with Indian tribes and attempting to get a land cession. And they would say, we represent, the president, your great father, or Congress, your great father. It's usually the president. But the great father idea is this trustee, this paternal entity out there who has your best interests in mind. But you're the ward, and you are not capable of making rational decisions yet. You're in a state of pupillage. So we're going to take care of it, all right? That's where this ward great father relationship comes from. So this particular Supreme Court case, Cherokee Nation versus Georgia, was never a case. It was thrown out. It was never heard. But the decision rendered by John Marshall was that these are domestic dependent nations. They can't sue. They can't come to the United States as independent nations. They are in a state of pupillage. The United States has a trust relationship with them. So we are both obligated, the United States people are both obligated to protect the tribes and to protect their assets. All right? So, double-edged sword. It recognizes Indian sovereignty. It recognizes the right of Indians to exist, but it takes away from any independence and declares plenary authority. The third of the three cases is Worcester versus Georgia. Worcester versus Georgia. We're almost out of time. Sorry about that. All right, in 5 minutes, we're going to get to the third case. And by the way, the second two of the three cases, these are sometimes referred to as the Cherokee cases. Okay. The first one is not a Cherokee case, Johnson versus McIntosh and Palmer Creeks, but the last two are actually the Cherokee cases. You'll hear about the trilogy. These are the three cases that really matter. the Supreme Court of the United States heard a case involving a guy by the name of Samuel Worcester, who was a missionary from Massachusetts, I think it was, living among the Cherokees, and he was involved in this, the Cherokee, the land lotteries and all this sort of thing, the overrunning of Cherokee Nation by citizens of the state of Georgia. And anyway, Chief Justice, the Supreme Court did hear this one. The case was, the decision was rendered in 1832. So the Supreme Court found in favor of Samuel Worcester. The state of Georgia lost the case. And basically what this was about was this non-Indian was jailed by the state of Georgia for violating state law in Indian country. So he was in the Cherokee Nation, but the state of Georgia extended its laws over into the territory of the Cherokee Nation, threw him in jail. And so this case was whether or not the state of Georgia had the authority to enforce its own laws within Indian country, which is the Cherokee Nation. And the opinion was specific, very, very specific. It said, no, the state of Georgia cannot extend its jurisdiction into Indian country. And anyway, this decision is what established the United States legal precedent that states cannot have authority within Indian country, okay? Which means, what is Indian country, all right? So that's a big question. We know that the states can't have authority unless Congress gives it to them specifically, as in the Public Law 280, which happened. We'll talk about that another time.